So guys, welcome once again to another episode where we are going to do an introduction to the law of succession. So the law of succession in Kenya was introduced around the year 1981 by a particular ordinance. So the law of succession in Kenya is governed by the Law of Succession Act Cap 160, and that time before this law of succession was introduced, we used to have customary law. And customary law was permitted provided that it was not repugnant to justice and morality. So under the law of succession, succession refers to the act of transferring of rights, obligations, status of the deceased person or title of the deceased person to the beneficiaries or to the persons intended by the deceased person. So beneficiaries may include friends, family, relatives, or whoever the deceased person intends the property is to be given to. So we've got two categories of succession. We've got tested succession and intestate succession. So under tested succession, this is whereby someone dies after he or she had written a will, and a will is that document that provides for who are to inherit the deceased person's property. So will is written under tested succession, and the will dictates the owners of properties upon death of the deceased person or the testator. The testator is the person who writes the will, and under the will there is an executor, and the executor obtains the power from the will, and the executor is the person who is left with that mandate of dealing with this property of the testator upon the death of the testator. So under intestate succession, this is where someone dies without writing a will for particular reasons, and the property there is governed, or the property that this person leaves behind is under the control of the administrator. So the administrator is appointed by the court under the document called letter of the grant of administration. That letter is the one that gives the administrator the power to deal with the property that was left behind by the deceased person. So we've got circumstances where a deceased person where property of the deceased may be passed even without a will. So a property can also be passed, property of the deceased can be passed where there is no will under circumstances of joint tenancy or the doctrine of survivorship, under nomination, and the third one is under the doctrine of donatio mortis causae. So under those three circumstances is whereby a property can be passed even without a will. So this is under the doctrine of joint tenancy or survivorship, the doctrine of nomination, and the doctrine of donatio mortis causae. So under the doctrine of joint tenancy, this is whereby this property was being held by two people, and one person dies, and automatically the law of succession will not apply here, because the property that is left behind will remain to the person who is alive. And the doctrine of nomination, this is whereby a nominator is appointed, a nominee is appointed by the nominator to deal with the third parties. And third parties, these are beneficiaries, these are people who claim some title in that particular property. So under the doctrine of donatio mortis causae, it was held in the case of Cain versus Moon that gift is left behind, and a gift is left by the deceased person. And this gift, we've got conditions that were brought there in that case, that this gift must be conditional upon the death of the deceased, and the subject matter must be clear. The subject matter must be to some particular owners of that gift. So we're going to look into those circumstances, and they've got advantages of writing a will, because when you write a will, these are the benefits of writing a will. So when you write a will, it just tends to avoid conflicts among the beneficiaries, because there is some certain provisions, there's some certain instructions as to how this property it is to be distributed as it was intended by the deceased person. So it also discloses some properties that were not visible to people, or that will have otherwise been lost if not this will was written. So it also avoids intestacy. These are scenarios whereby someone dies without writing a will. So just an introduction to this law of succession. It's an interesting unit, and just stay tuned, because we are going to give you more and more information concerning this unit. Intestacy is provided for under section 32 to 42 of the Law of Succession Act. So that is intestate succession or intestacy. So just stay tuned, guys. We've got also that case of privileged will. We're going also to look deeply into the wills. We've got privileged will, that is the will that is only allowed or permitted to people like armed forces, people who are marine warriors, people who are fighting in seas, and people, because these people do not have that time to write. Like, they can just make a will through a phone message, you know. But we've got also the procedure is to be followed in the writing of the will. So we must have witnesses. But under those circumstances, there is no need of witnesses. You got me? Get me, guys? So a will, when you write a will, that process of writing, coming up with a will, must have witnesses to witness to that will, and these witnesses are not supposed to be beneficiaries. Yeah, and a will can be revoked. That's the characteristics of one of the characteristics of a will. This will can be amended. This you can amend that will. You can add extra provisions to that will. Or maybe if there is some property you obtained after you had already written a will, you can go and scrap the initial will and then come up with a new will that gives clear about that new property. So there's more that you need to know about the law of succession. Just subscribe to Scott's Legal channel and stay tuned. So come on, guys, we're gonna do this.